Article 6. Everybody see that? Paragraph 2, which is going to start right here, and I'm going to read it to you. Okay? And basically what it says is this Constitution and the laws of the United States, which shall be made in pursuance thereof, and the treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary or notwithstanding. When they say notwithstanding, that means notwithstanding in law. That means that's a legal definition. Notwithstanding means notwithstanding in law. Now, a very important case, Marbury versus Madison, 5 U.S. 137. It's recorded at Volume 5, right here. It's an 1803 case, Marbury versus Madison. It's recorded in Volume 5, page 137. Now, basically what this case states, and I'm telling you right now, if you want to use a case to cite for any purpose in court, you have to read the case. If you haven't read the case, and formed a basis upon which a logical determination in your mind could have been reached to form an opinion as to why you should do what you're going to do, then the judge will throw your case out. So read your cases. Don't just quote cases, because you won't win. If the judge ever pins you down and starts asking you some merits of the case, and you can't even understand what the case is about, 9 times out of 10, he's just going to throw your case in the can. So make sure you read the case. This is one of the leading cases in the history of the United States of America. The opinion of the court was given by the Honorable Judge John Marshall, Chief Justice of the Supreme Court. His opinion was anything that is in conflict is null and void of law. Clearly, he said that for a secondary law to come in conflict with the supreme law was illogical. For certainly the supreme law would prevail over all other law, and certainly our forefathers had intended that the supreme law would be the basis of all law. And for any law to come in conflict would be null and void of law. It would bear no power to enforce. It would bear no obligation to obey. It would purport to settle as if it never existed, for unconstitutionality would date from the enactment of such a law, not from the date so branded in an open court of law. No courts are bound to uphold it, and no citizens are bound to obey it. It operates as a mere nullity or a fiction of law, which means it doesn't exist in law. Now let me give you an example in today's timing as to how effective this is. This argument is so effective that it literally nullifies the Brady Bill. It nullifies the crime bill that takes away the right of the people to keep and bear arms on these 19